Hey folks, today we're talking about what you got to prove to win a South Carolina accident injury case. The legal term is negligence, and I'm going to break that down into terms that make sense for normal folks like you instead of legalese. So the first question is, what does negligence even mean? Negligence means carelessness. So let's talk about what you got to prove negligence. Law books will tell you got to prove the at-fault party, called the defendant, owed a duty of care and breached that duty, which proximately caused you damages. Let me break that down into normal human terms. You got to prove the defendant owed a legal responsibility to keep you safe and violated that responsibility, which likely caused you harm and loss. So let's talk about the duty of care, which is the legal responsibility to keep you safe. Here's some examples of that responsibility. If you're riding in a car or riding on a motorcycle, other motorists have a responsibility to drive safely. If you're a customer in a store, the store has the responsibility to keep its floors free of tripping or slipping hazards or warn you if they exist. If you're a resident in a nursing home or assisted living facility, the facility has the responsibility to provide proper care and a safe environment. It can be pretty easy in some car or motorcycle accident cases to prove the responsibility, but it gets real complicated real fast, especially if it involves a tractor-trailer crash, because those cases can be governed by highly complex federal regulations. In other cases, it's just best to seek guidance from an experienced accident injury attorney because proving the responsibility is complicated. So once you prove the responsibility exists, you got to prove the breach of duty. That means you prove the defendant broke a safety rule. In a car or motorcycle accident case, you prove the defendant broke a traffic law. In other cases, you'll need an experienced accident injury attorney to point you the right way because there's sources that can show the existence of that responsibility and how it can be broken. And those include industry standards, the defendant's own policies and procedures, case law, which is written appeals court decisions. Your attorney will also know if your case requires an expert to prove this critical aspect to your case. For example, if you're the victim of medical malpractice or nursing home neglect or abuse, the law requires you to have an expert. So once you've proven the breach of duty, you got to prove proximate cause. All proximate cause means is breaking the safety rule likely caused you harm or loss. It sounds pretty simple, and it should be, but it gets real complicated real fast if you've had a prior injury. In cases like that, the insurance company uses proximate cause to argue you were already hurt and this was going to happen anyway. I see it a lot in spinal injury cases where my clients had neck or back pain on and off over the years, but then suffers an accident which causes the need for an operation. In cases like that, I often meet with my client surgeon who confirms the accident worsened the prior injury to the point my client needed the operation. Then I present the insurance company with a questionnaire completed by the surgeon to prove proximate cause. When you prove proximate cause, then you can prove damages. And damages is a legal term that actually reflects exactly what it means. Damages means harm and loss. It is the cost of negligence to you. And South Carolina law offers several categories of damages you can prove. The first is economic damages. That just means it's easy to put a dollar value on it. We're talking about medical bills and lost income. The next category is non-economic damages. That means it's hard to put a dollar value on these. A lot of lawyers call them pain and suffering, but it's more than that, so I call it human loss. And by the way, this is where an experienced accident injury attorney can really shine for you and tell the story of what you went through as a result of the accident and your injuries. So non-economic damages includes things like pain and suffering, but it also includes physical or mental difficulties and disabilities. That means anything that became harder or impossible as a result of your injuries. And then there's loss of enjoyment of life, everything you missed out on as a result of your injuries. You may have also suffered emotional trauma. If you're married, your spouse has a case called loss of consortium. All that means is damage to your marriage as a result of your injuries. You may need future medical care, and that's a lot harder to prove than past medical care. It requires us to go to your doctor to find out what that care is and then get an estimate of how much it'll cost. If your case goes to trial, it'll require an expert called an economist to reduce those costs down to present value. And then there's punitive damages. Those are for extreme cases. They're designed to compensate you for injury from recklessness. And they're also designed to make an example of the defendant so other folks are deterred from doing the same thing. A classic example of a case that's eligible for punitive damages is a DUI defendant who causes an accident and seriously injures you. To protect your right to get punitive damages and help you figure out the right amount, you're going to need an experienced accident injury attorney to help you. These damages are hard to prove, and to get the right amount, you've got to make sure you follow and prove your entitlement to them through several legal factors that are set out in South Carolina law. That was a lot. Thanks for hanging in there with me, folks. If you've been seriously injured in an accident, the best and right thing for you to do is to get guidance from an experienced accident injury attorney. I know you don't want to go to a lawyer, but you don't want to go to the doctor either. It's just sometimes you need professional help to make sure you don't make a bad situation worse. Protect your rights, protect your family's rights, protect your peace of mind. If you contact me, I'm not going to strong arm you to hire me. I'm going to answer your questions and let you decide if working with me is right for you. I thank you for thinking about this with me, and I hope I see you soon.